Welcome, everybody. On behalf of the Saskatchewan Federation of Police Officers, we just want to thank you all for logging on today. We have a really great live webinar, legal briefing. Are you prepared? We got two amazing hosts that are going to assist us with this presentation. We have Darren Krauser with McDougall Gauley and Jessica Bahoon. Darren's been with McDougall Gauley for over 13 years, and kind of an interesting story. Jessica Bahoon's dad was actually one of my NCOs back in the day. Both of them bring a wealth of knowledge and have worked with our associations across the province on all legal matters and labor matters. So if you don't already know, who are we? The Saskatchewan Federation of Police Officers represents over 1,500 members across the province in Regina, Saskatoon, Prince Albert, Weyburn, Estevan, and Moose Jaw. We also represent the Regina Senior Officers Association and the Saskatoon Senior Officers Association. We have an amazing board with our Vice President North, Chris Rhodes, who is also the president of the Saskatoon Police Association. Taylor Elder, who is a former president of the Moose Jaw Police Association, is our South Vice President, and our executive officer is Darren Wilcox, and myself, your president, Casey Ward. So why do we do these webinars? So we first started off actually with a mental health webinar. Now, what we want to do is we want to provide resources to our members across the province. We know, communication is tough these days. So looking at different things like emails and trying to get this information out. So we thought we'd start to host webinars for our members so that they could tend to watch or resources for them later. We're committed to building community safety. So out of the three webinars, our first one was on mental health, and it was a members only webinar. And then the second one was actually a provincial one. Anyone could sign on. We had a lot of people from our community, and that represented our fundraising magazine for family violence. So we had a lot of our community partners and a lot of people from the schools, different resources, how to identify family violence and what to do if you do see it. So we're really trying to show the good work that our members do, not only within their service, but across our province. We really want to promote the great things our people are doing. We know our officers day in and day out are taking lots of calls for service, doing amazing investigations, working on data quality, access to information. Our members are doing a lot of good things. And there's a lot of things our people in the public actually do not know what we do. So we're just trying to show that our members are out there working hard and also do a lot of stuff out in the community also. So with that, I really want to thank everyone for joining today. And I'm going to turn it over to our legal experts and our great live webinar legal briefing. Are you prepared?
Hello, everyone. I hope you're doing well tonight. We're going to present on a couple things. I'm going to talk a little bit about what happens when officers are under investigation. In some ways, obviously, you guys are all professional investigators. But this is a little bit, what do you do when the tables have been turned on you? So I'm going to present a little bit on that. And then Jessica's going to talk a little bit about coroners, inquests, and some of the things you might expect with that. So there's a couple different types of investigations that members will sometimes find themselves in. Each one of these has kind of its own unique character, and there's different factors to consider with each one. There's also a number of things sort of occurring simultaneously. So some of these will have some interactions within each other, and it's important to kind of seek legal advice because there's a lot of different things you got to consider on each one of these. The three types, just generally speaking, that we'll be talking about are CERT, or Serious Incident Response Team. That one's a pretty common one that we run into. Obviously, kind of any officers involved shooting or use of force where there's an injury, and some other factors, some other things that can occur. We get a lot of those, and there's a lot of times that you'll be involved in that. The second one's sort of related. There's a lot of bleed through on these two, but would just be sort of general criminal allegations. That would involve officers who are charged with off-duty conduct that isn't a CERT thing, but it's just other types of criminal allegations. And then lastly, administrative investigations. And it's important to kind of keep in track in your mind about, okay, well, which one's happening to me, or what am I giving advice on to another member? And like I said, there's a lot of interactions between all of these different things, and sometimes they're happening more than one at a time. So generally speaking, when we're talking about, what to expect and what officers should kind of expect from this, the first thing is it's stressful. And I wouldn't underestimate that. This is something where even if you've done absolutely everything right, sometimes, especially in CERT situations, it's mandated to be investigated. And it's stressful. It's very stressful. So I wouldn't underestimate that. You also need to understand the sort of different level of jeopardy and potential consequences that you can have in any of these situations. Um, a lot of this, as far as dealing with legal, is sort of dealing with the risk management and trying to assess, okay, well, what are my rights and obligations here? What are these different scenarios that I'm looking at? What is the cost of giving a statement or not? And there's certain scenarios where you have these sort of things kind of interacting with each other. So you might be asked to give an admin statement where there's potential criminal jeopardy also. So you kind of have to weigh potentially, okay, what's the cost of not giving an admin statement? Well, frankly, it could be your job. But then what is the cost of giving one in a certain situation? It could be your freedom. It could be something very serious. The last thing to kind of think about to what to expect is, well, what are the investigators going to be like? Frankly, you kind of get a whole mix. You have investigators that are very good and understand the process. The CERT investigators generally, I'd say, are very good, the ones we've dealt with. But sometimes you get a mixed bag, and there's some that add some pressure to things. Sometimes they don't know all the processes or what's permitted or what the obligations are. So it's really important to seek legal advice, and that's kind of the next slide. So when we talk about seeking legal advice, it's a little different in my experience, and I do a lot of work in criminal defense and professional discipline. But when it comes to police officers, it's a little bit different type of advice we're often giving. That's because there's a little bit of culture in policing. I think it's less so. When I first started, it was stronger, but I think things have changed a little bit. There was a little bit of a culture of police where only guilty people talk to lawyers. So there's a little bit of a sense, well, why am I lawyering up? That's something that the bad guys do, or I only do that if I have something to hide. I think we've done a lot of work, and I think the culture's changed quite a bit. There are just some general benefits to talking to a lawyer. One of those is talking through the incident, sort of the one person you can have some confidential discussions with and actually go through an incident or go through what's going on and get some feedback about that without having to worry about that's something that's going to be disclosed. It can give you some peace of mind. Doesn't mean that you're talking to a lawyer and our advice is going to be, don't say anything, that kind of thing. But it can give you some peace of mind. Some things, the advice you'll get though is sometimes we'll give you some feedback. So someone might explain, well, this is what I did in this scenario. These were my actions. And, we might say, well, okay, but what about this? Or what about that? Or you're forgetting to add this. I see this in your report, but, you didn't mention that when you talked to me. So a little bit of giving some feedback and it's giving some information to someone who can help convey their story a little bit better if you do want to give a statement. Another thing we do is witness preparation. So that would be, you'd sit down with a member and kind of go through everything in detail and explain what's going to be important if you're going to go in for a statement. Some tips on giving evidence. And I mean, lots of officers have testified in court. They understand how to do that, but it's a sort of has a little bit different character to it. So we'll do some witness preparation. Not that we're saying what to say, but how to convey it. Sometimes we're saying what to say in the sense of, hey, you forgot this. You should make sure you include that when you tell your statement. We don't, as a blanket rule, we don't say, don't give a statement or shut up and don't say anything. All we really do is sort of lay out the options, give you an explanation of what you can do, what your options are, and then ultimately you have to make that decision. I will say, as a rule of thumb, and just a general rule of thumb, again, not that you shouldn't give a statement, but I think it's really important, and it's generally a best practice not to say anything if you've been asked if there's an investigation going on until you've spoken to legal counsel. That's really important, just so you can kind of understand all the consequences and all the things that can be going on in the background. The first general category of things, and this is actually quite confusing. It's not intuitive in my mind, some of the rights and obligations you have under CERT, but CERT is sort of the first thing I wanted to talk about, and that is the Serious Incident Response Team. It's a civilian-led investigation unit, applies to all police, RCMP, and municipal police, city police, all throughout the province. It deals with on-duty and some types of off-duty conduct. Civilian-led, so it's Greg Goodalow is the executive director. Actually, Greg, I know Greg. He's actually a very good guy. He's very reasonable, and most of the investigators he have are retired police officers. So they actually have a really good group right now. It's sort of, this is their first run at it, and I think they're doing a really good job. But that's sort of what the organization is. What triggers a cert? Under the legislation, investigations will occur when a person suffers serious injury or death, either in police custody or a result of a police officer's actions. That's the one category. So you often see those in officer-involved shootings, or if there's a pursuit, or if there's any sort of use of force during an arrest where there's a serious injury or a death that automatically is triggered. The off-duty conduct involves any allegation of sexual assault or interpersonal violence. So it's actually when CERT kind of came online here, the office was inundated with a bunch of sort of historical sexual assault allegations. And they kind of have been working their way through that. And I understand that was actually a pretty common thing, as a similar thing to CERT was introduced in other provinces. But that's generally what triggers a CERT. So once something like that happens under this category, then immediately there's a couple things that automatically are triggered. The most important thing from your perspective is to determine initially, am I a subject officer? Am I dealing with someone who's a subject officer? Or am I a witness officer? Or am I dealing with someone who's a witness officer? Those are the two distinctions. Now, it's very critical. If one thing that I just put a little star on here to remember and know is really important, it's finding out what category or designation the member is. Very important, because it really changes what the obligations are, what the rights are. And to complicate matters slightly, that can change throughout a process. So you can imagine in an investigation, there's some information that comes in that this person might just be a witness officer. We see this lots, actually. Initially get a call and say, hey, this person's been designated a witness officer. Then as they're doing some initial investigation, they determine, well, actually, this person was actually involved a little bit more. So now they're going to become a subject officer. So it's really important that you understand which category you are. Totally different advice will be given for each one. So it's really essential that you get that right. The first category of subject officers is defined as if a member's acts or omissions were a cause or contributed to a serious incident as defined in the CERT legislation. So if you were the officer that's involved, or if you're helping an officer who is involved directly in the cause or contributed to the serious incident, they're going to be a subject officer. That can kind of fit in a couple different categories. It doesn't necessarily mean that you're the individual, say, in a police-involved shooting. It doesn't necessarily mean that you were the one who fired the shot. Sometimes you can be involved in other layers, but if it's a cause or contributed to the incident, you'll be designated as subject officer. Subject officers, it's really important to remember that this is just a designation that's basically defined by the legislation. It creates this particular framework. It doesn't mean that this person has done anything wrong. It's actually meant as a bit of a protection for anyone that's going to be investigated for this. It gives you certain rights that a witness officer doesn't have. Every officer involved in a shooting, essentially, no matter how justified the ultimate result will be designated as a subject officer. So again, it doesn't imply that any wrongdoing has happened. But that being said, you should be aware that it's going to be unfun. It's not going to be a good process to go through as a subject officer. It's very isolating. There's a lot of steps procedurally that will be done that can make you feel like you've done something wrong, or that you're guilty of something, or that you get your guard up a little bit. Usually involves isolating that officer. So subject officers will be separated from everyone. And that's just because for the investigation, they don't want people kind of talking to each other or the evidence to be contaminated. They'll also be screened from the file. So it's really important, if you're assisting a member as a rep, or if you are the member who is a subject officer, you don't want to attempt to access the file. CERT will lock it down pretty quick, and they'll be able to tell if you were looking at it. So you don't want to be accessing it, again, because they'll see that as potentially contaminating the investigation. So if you're advising someone on that, you'll want to let them know, don't look at the file, don't access it unless you're asked to. So you're going to be isolated, you're going to be locked from the file. They're going to confiscate your firearm, your duty belt, your uniform in many cases. And in some cases, you'll get some pressure to give a statement. We've seen that a little bit more recently, but you need to keep in mind you get to kind of drive the bus here. But you also get to take care of yourself and take some time. So it's really important, in my view, that you get some preliminary legal advice, or you advise your officer to speak to a lawyer. Again, because they're going to feel isolated, and sometimes it can feel like, okay, well, I just want to get this over with so that I can get back to my friends and colleagues and kind of get back in the mix of things. I want to get this over with. I really encourage people to take the time to kind of recover from an incident, and also seek legal advice. Now, the one caveat on that is before you can talk to the legal, you're actually supposed to complete your initial notes. It's just your summary notes. You don't actually have to hand them over to CERT, but there's some case law that says you're supposed to complete your preliminary notes. There's also a little bit of a question, and likely in a scenario where there's like an active incident going on. So say there's either multiple suspects, there's a bit of a situation where there's a number of officers involved. One individual has been shot by police. That member might be involved in that, but there still might be other suspects out there, or other individuals that are going to cause a threat. There is some obligation on that officer to provide some initial report, just orally even, to a commander or something like that, to say, okay, well, this is a situation, this is what's going on, these are the individuals, just some kind of brief information, so that you can't just be involved in a situation and say, all right, well, I'm out of here now, I'll talk to you later. There is a duty to give some information if there's an incident that's unfolding currently. One thing you should keep in mind as well is that you do have time to kind of decompress and get your head in order again before you give a statement. There's lots of trauma-informed interview strategies and things like that for people that are victims of things. Not to say that an individual that's involved in this is a victim necessarily, but you are through a traumatic event. And it's important to take the time to kind of collect your thoughts, take some rest, think about things, talk to legal, and you're entitled to do that. We've had some cases where CERT's been given some pressure to people to give statements right away. But again, you have to remember, you get to drive the bus if you're the subject officer. You don't have to give a statement. So if you don't want to, you can say, well, no, I'll decide when I'm good and ready. And so you shouldn't feel compelled to do that. The rights and obligations you have, you have some pretty good protections if you're a subject officer. You are not obligated to provide a statement. You can and should speak to legal. You're also entitled to have a rep with you. So you have a lot of things that can kind of protect you, and you have some options how you want to proceed. Like I said, there are no formal timelines that are really being required to be met, because you don't have to give a statement. So ultimately you can say, well, look, I need a little bit more time. And I've had cases where, an officer in Regina was actually involved in a shooting there's a fatality. They were leaving on a trip basically the next day or the day after. And CERT, obviously agreed, okay, well, you go do your trip, you go do whatever you got to do. And when you come back, we'll set up an interview if you're interested in that. Like I said, you're permitted to have time to recover. That includes if you want to talk to your priest, or your clergyman, or counselor, or your spouse. I'd advise not to talk about the incident, but if you need something to kind of help yourself kind of settle down after, you should do that and take the time to do that. As far as your options go, you don't have to provide a statement, and you can kind of do anything in between. You can say, I'm not giving any statement, that's it. You can say, I'll give you my report or my notes if you wish. You can do a separate written statement and say, that's it. You can give the written statement and that's all you get. You could give the written statement and say, okay, here's my written statement, but I'll come in and I'll answer any questions if you have any afterwards. Or you can say, all right, I'll come in and submit myself to a full interview. I found most members, most officers across RCMP and police, a lot of them choose to do a written statement and then often go in and answer questions. And the reason they do that is because they like to be able to write it out and then have the lawyer review it and say, hey, did I include everything I need to include? Because sometimes in a statement or in an interview, you might forget something that's going to be important, and it just takes some of the pressure off if you have that in a written statement. So again, it's best to write it out in my view, even if you're not going to hand it in, but so you can review it with the lawyer. Statements can be used if you give a statement. They're not always warned. Sometimes they are. I'd say in most cases they are, but I've had a lot where I've gone in for CERT interviews and surprisingly they're not actually warned. So a little bit of a question mark on whether that ultimately would be admissible down the road without any rights and warnings, but it does happen. Generally speaking, though, we advise people, if you're going in as a subject officer, the statement can be used against you in a criminal proceeding, but arguably not in a discipline proceeding or a civil proceeding. So you have some protections for certain types of proceedings, but ultimately there is some risk that if you give a statement, that'll be used against you in a criminal proceeding. The next category, sort of separate, you don't have as many options, but is witness officers. Witness officers, defined as an officer who basically witnessed a serious incident. They weren't the ones that were directly involved or weren't a contributing cause to it, but they were just a witness to it. So if you get designated as a witness officer, your rights and obligations are a little bit different, a little more limited. You are obligated to provide a statement and participate in an interview. You do get to speak to legal, and you can have a rep with you. You maybe process similarly to a subject officer. That sometimes does happen. So sometimes, even as a witness officer, they might take your gun, they might take your clothes, because you're going to, again, it could be something that they're investigating. That's a little more rare, but it can happen. If that does happen, you kind of want to ask and make sure, are you sure I'm a witness officer, or did you guys mix something up? These generally are not warned interviews because they're obligated to there's a question of whether it's voluntary. In fact, it's not. And the statements can't be used against you in a criminal proceeding, again, because they're compelled, or other civil proceedings. But importantly, they can be used against you in a police act or discipline proceeding. So our general advice is, if you're involved in a cert, or if you're assisting a member who's involved in a cert, just call legal. We've given you some contact information for us. You can call us anytime. All of those numbers, we switched to Zoom phones recently. So we actually get the calls and texts to our cell phones. And we actually have a Signal group chat even in our group. And so we can coordinate. It doesn't matter what time, whatever. Shoot us a text, give us a call, and we'll coordinate someone will be able to help you for sure. Timelines for CERT. The CERT has to complete their report within 90 days. And after that, it can be forwarded to the Crown for an opinion. Lots of times it isn't if it's a clear-cut case, but sometimes it is. Now, I flagged in here, it can take over a year. I've had some that are over a year to make a determination whether charges are laid. And we've had some cases where, after a CERT investigation or any other investigation, it's forwarded to the Crown prosecutor for an opinion. When it comes back, a year later or longer, sometimes to say charges are recommended. And then the officer faces those charges. Related to CERT, but sort of in a different category, because CERT can cover off-duty conduct if it falls under sexual assault or interpersonal violence. The other kind of general category of investigations that police officers find themselves, what we just call other criminal. So that just means sort of any other allegation, any other criminal allegation. And that can be, we've seen cases involving fraud, drinking and driving, kind of anything, any other criminal code violation that doesn't fall under a CERT. Again, what you should be doing and advising people is, again, contact the association and then contact legal. The process would be similar to what you'd see in a subject officer and sort of any accused that you guys would have dealt with in your careers. You'd get a right to counsel. You'd be asked about providing a warrant statement. And you do not have to provide the statement. And again, it usually goes to the Crown for an opinion. And that's something that can often cause pretty big delays. Once charges are either laid or sometimes just during the investigation, we see that there's interim suspensions and reassignments. Those would be common. It's not determinative wrongdoing, but it is something that happens. So yeah, administrative statements. Generally, if you're asked the question, what are my obligations with administrative statements? If you're asked or you're being ordered to do one, you have to give a statement. You have to give it in the sense of your career depends on it. But like I said, sometimes, there's some other things in the background. So again, you are entitled to talk to legal and have a rep present. But the big question that you see in these situations is, well, what if I have criminal jeopardy as well? What if there's a potential criminal allegation, or if I go in and give the statement, I'm going to be telling them about something that might involve a criminal allegation that maybe they don't know about yet, or maybe they wouldn't find out about it but for me giving a statement. Or what if there's this other investigation that's going on and these are running parallel? In my experience, RCMP and Police Act stuff in the province, the agencies have been really good at holding off on a admin statement or an administrative investigation until the criminal side is done. And sometimes that takes a long time because, if there's a criminal charge, sometimes that can take years to sort out. And often we've seen them hold off. There's nothing in the legislation that says they have to. And it depends on the case, but that's kind of the main question that people have. What if I have criminal jeopardy as well? Now, the concern we have in these situations is, well, what if you go in for an interview? One, will that statement be used against the member in a criminal proceeding? And two, can any derivative information that was obtained be used in the criminal proceeding? So for instance, maybe I'll go in and I have some confidence that if I tell the officers this in an admin statement, they're not going to be able to just use my statement in court proceeding, but I'm going to tell them something where it's not going to be very hard for them to go investigate that and find another way to use that. And that's something that's obviously the two main concerns in these areas. Now, under the Police Act, there is some limited and somewhat confusing protection. There's not a lot of case law on this, so it's somewhat untested. But under Section 39, Sub 7 of the Police Act, public complaints are deemed to be privileged. So if there's a public complaint that then is being investigated with an administrative statement, arguably, then that's privileged and there is some protections. Conversely, though, internal investigations, so if an officer is being investigated because of a certain driving behavior or something that wasn't a public concern but was an internal concern, those protections might not apply. So under the legislation, there's actually some limited protections, but it's not always clear how much that's going to apply. So again, it's something that's important in our view to speak to legal about it before you go and give a statement. Under the common law, there's just the general voluntariness principle. If you're being compelled in the sense you're being ordered to give a statement because it's your job or you're being ordered by a superior or a statute requirement, then arguably that's not voluntary. And we see lots of cases that support that, but I would say it's not a guarantee in every case. The case law is evolving and changing at any time. We were a little bit surprised years ago. The Justice Department sort of took the stance in one case we had where they believed that they could use the statements. Ultimately didn't go all the way through there, but there was some indication from them that they might try to use them in certain cases. Again, as well, the Crown may try to obtain this information through other means after you've given a statement. So even though there might be some protections for derivative evidence, that's never going to be 100%. So it's something you got to be a little bit cautious of and concerned about. There are some general limits on what your obligation is to give an administrative statement. Generally speaking, if you're being asked to provide one, you will have to comply. Now, there are some caveats to that. One, you can sort of assess, the scope of the investigation. And there is some case law that says, well, if you've already sufficiently provided this information, either through notes and reports and other interviews, then, this additional one, is it really going to the admin investigation? Or is it now getting into, are we looking for some kind of criminal allegation or criminal investigation? Other factors are if it's off-duty or on-duty conduct. You might want to ask what the purpose of the interview is or what the questions are. And again, have you already sufficiently answered this? There is the option potentially to refuse to cooperate and take the stance, well, no, I've already done enough to satisfy my obligations under these sections and under what I've been ordered to do. You're rolling the dice a little bit, obviously, because they could take that as you're not following orders and that's a disciplinary offense and seek your dismissal. But that's something, again, you want to assess with legal. It's very case dependent, very circumstance dependent. And I will say we have had members that we've talked to that administrative statements are being sought and they decide not to give them to take the risk for their career because there's potentially greater jeopardy. So it's really important that you would talk to legal before you decided to do that. There are some limited protections, but there's sort of no guarantees when it comes to the law. There's always, one side is trying to do one thing, one side's trying to do the other, and a judge ultimately has to make decisions. And there's always carve outs for, well, maybe we can use a statement in this scenario, or maybe we can't use the statement in this scenario. So nothing's ever 100%. And so you'll want to get that advice that sort of where you are on that continuum. I'm taking the risks.
Hi, everyone. I'm going to be fairly brief today for two reasons. The first being I'm cognizant of time, and then the second is I've been sick, so my voice is a bit hoarse, and I can only stand hearing it in this tone for so long. Today, in this portion of the session, we'll be focusing on coroner's inquests. I'll be going through a high-level overview of what they are, why you might be involved, and then how best to protect yourself professionally if you do become involved. So to begin, what a coroner's inquest is and also what it's not. In Saskatchewan, coroner's inquests are governed by the Coroner's Act. An inquest is a public-facing fact-finding hearing. It is overseen by an inquest coroner, who is usually someone who is legally trained, often a lawyer, and it is heard before a 6-person civilian jury. It looks and feels like a trial often in that witnesses testify under oath, evidence is called, and lawyers are asking questions of the witnesses, but it's not a trial. An inquest, it doesn't assign any fault, it doesn't make findings of guilt or innocence, it doesn't result in disciplinary action, and it doesn't decide any civil liability. And so with that, I'll just say that the jury in an inquest, it does have a very defined role in what it's to determine at the end of the inquest. Its job is limited to answering a specific set of questions. The first question is who the deceased was. The second is when and where the death occurred. The third question is by what means the death occurred, and the categories are either natural, accidental, suicide, homicide, or undetermined. And one thing I will note that in this context, homicide, it doesn't have any legal implications like we would typically think. It simply means that the death was caused by the actions of another human being. The jury is also tasked with determining the cause of death, so that refers to the medical cause. And then finally, the jury is to make recommendations that are aimed at preventing similar deaths in the future. And these recommendations are what are the key takeaway from these inquests. They can be directed at things like policy, training, staffing. They can be at an agency or an individual level, sometimes at the broader system level. So even though there's no blame or fault determined at the end of it, the recommendations still can affect policing in very real ways. And so next we'll talk about when inquests happen and when they don't. There are certain deaths in the province that trigger a mandatory inquest. An inquest is mandatory in Saskatchewan when a person dies in custody. And in the Coroner's Act, in custody has a specific meaning. It means when someone is an inmate of a jail, a correctional facility, detention cells, or a lockup. And there is an exception to that if the death is from either natural causes or is unpreventable. And it's important that officers understand too that this is different than sort of what triggers a certain investigation, in that not all police involved deaths trigger mandatory inquests. For mandatory inquests, it's the location of the death that matters, not the level of the police involvement in the death that matters. So for example, if the death occurs while someone is in cells, that triggers a mandatory inquest. But if a death occurs while someone is detained while roadside, that wouldn't arguably trigger a mandatory inquest. There are also discretionary inquests. So a situation like that might result in a discretionary inquest, but the inquest wouldn't necessarily be mandatory. And in practice, I will also say that the coroner service usually waits until CERT has completed its investigation and finalized its reports before proceeding with an inquest, or in those discretionary cases, deciding whether or not it's going to proceed with an inquest. So for this next topic, we'll talk a bit about why and how police get involved in inquests. Police involvement is very common when it comes to inquests. Think, one of the core purposes of the inquest, like I've discussed, is to give the jury a complete, clear, sort of full picture of what led to a death. And police evidence also often plays a significant role in creating that narrative. And it's not always about scrutinizing police conduct. In many cases, it's just that the police involvement did play a part in explaining the sequencing and the events and the context and what ultimately surrounded that death and sort of what might have followed immediately after. So you as an officer might get involved if you were directly involved in the incident that led to the person's death. You were a supervisor or manager of someone who was involved in the death. You might be an officer who just arrived on scene afterward. You might have just participated in the investigation in some way. Most often, the lead investigators are called at inquests. And so if you are called, you must attend and you must testify. That is an obligation that you have. And you can expect questions from coroner's counsel. So that's the counsel that's acting for the coroner service. Oftentimes, the family members of the deceased person may have lawyers, and if they've been granted standing, which we'll talk about in a minute, they could be asking you questions. There might be other interveners asking you questions. And an interesting component of this as well that's different from a typical trial is that jurors can ask the people who are testifying, the witnesses, specific questions throughout the process as well. So now to talk about standing. Standing means being allowed to participate actively in the inquest beyond just being a witness. So standing can be granted to anyone with a substantial interest in the proceedings or those who may be affected by its outcome, including individual officers. Requests for standing can be made in writing to the chief coroner themselves, and then they have the discretion to decide whether or not someone is granted standing. And this is where it becomes important for you to seek legal advice, or at least talk to your association rep to be put in touch with legal. There are some circumstances, of course, where you might have played a peripheral role and it might not make sense to apply for standing. But then, as I'll get into in a minute, there are certain situations where it's important for you to have that contact with legal and discuss whether it might make sense for you as an individual officer to apply for standing in any given case. And so why this standing matters and why you might want to get standing if you have been involved in a matter. You do receive the full disclosure before the inquest. You have the opportunity to review this with your own lawyer. Your lawyer can be present throughout the entire inquest itself. Your lawyer, in some situations, they always can, but they might not always. They can ask questions or cross-examine the other witnesses. And while you're testifying, your lawyer can object to any improper or inflammatory questions that are being asked of you. And you can think of a situation where family members have standing and they're cross-examining you. They might have some questions that bear no relevance to you, that are just pointing blame at you. If you have a lawyer, you have someone in your corner who can be objecting to those questions that are improper in that forum. Often the police service will have standing, but the point here is that those interests between the police service or the association and you as an individual officer, while often they might be in line, it's not always the case that they will be. So priorities between the individual officer and the exposure that the individual officer has in a certain case might be different than that of the service or the association. So having your own lawyer, or at least seeking that legal advice ahead of time, means that someone who is specifically focused on you and looking at your interests and is in your corner. So in preparing to testify and what to expect at the inquest, you should expect to have questions, like I said, from coroner's counsel, from other lawyers, from potentially family members, from the jurors themselves. And typical areas of questioning go to lines of your training and experience, what you might have observed, what decisions you made, and why you made certain decisions. And one question that I will say that officers will find particularly challenging, and one that is often asked, because if you think about it, at the end of the day, the jury is tasked with putting forward recommendations to prevent similar deaths. So officers are often asked, is there anything that you would have done differently in hindsight? So again, that's why there's benefit to sort of talking it through with a lawyer ahead of time, to thinking through those things. It's crafted by the juries to inform those recommendations and not to assign blame, but it's a question that does require thoughtful, careful consideration. You should also, like I said, if you have standing, you'll have the opportunity to review that disclosure with your counsel in advance. You should review it in advance. If you don't have standing, in any case, you want to make sure that you're reviewing, your reports and your notes or anything associated that you do have. You want to have an understanding of the scope and the issues at the inquest. You might want to review or refresh your memory on certain terms of terminology or certain policies, with, of course, the issues that are at play in mind. You'll want to do some witness preparation with your lawyer. And this goes back a bit to what Darren talked about. It's not a matter of us telling you what to say, but going through some general tips of, how to be a good witness, how to testify, how you should be listening to each question carefully, answering only what is asked of you, not speculating, not guessing or volunteering additional information and taking your time. So we'll go through some of those things and flag for you what the important considerations may be, and talk with you through some questions that we think might be asked of you. So you go into the situation more prepared than you otherwise would have been. Again, inquests are very public. They're often reported on in the media. Family members are present. So it goes beyond just offering your side of the story. And so now looking a bit at the use of evidence that is given at an inquest, there are certain protections that you do have when you're giving evidence at an inquest. There are some found within the Coroner's Act itself. So the evidence that you've given an inquest can't be used directly against you in criminal proceedings, civil lawsuits, or in disciplinary matters. If you have a lawyer, your counsel will review with you both Section 5 of the Canada Evidence Act and Section 9 of our Provincial Evidence Act. The Coroner's Counsel at the Coroner's Inquest usually goes through that as well. So that goes through your rights against self-incrimination. But there is a practical reality to that, in that there are other ways in which the evidence that you give can be used. So that evidence can't be used directly against you, but others can listen to that evidence and it can be used to influence, what questions are asked of you later on, or if you think about in a civil proceeding, what documents are requested through the civil production document process. So again, this is just another reason why preparing for your testimony at an inquest and having that preparation, or at least seeking some legal advice ahead of time, is important. And now just sort of a brief overview of why, as an officer, you should care about the evidence you're giving or about what the recommendations are. Again, even though inquests don't assign fault, the jury recommendations do carry weight. They can often influence police policy, influence training changes, operational expectations. Think of it even from a public scrutiny perspective. Again, these are things being reported on in the media. You think of the sort of steep rolling hill that social media can play, that can quickly spiral. So the evidence that you do give, it is important. It's often reported on and it can be scrutinized. So even without that wrongdoing, what happens at an inquest can affect, how you as an individual officer may be seen, and affect how policing or your association or your service is seen in the eye of the public as well. What I would say are sort of the biggest takeaways from what I've talked about as it relates to coroner inquest specifically. If you are notified of your involvement in an inquest, so you're subpoenaed or you hear that you're going to be called as a witness, I would suggest that you reach out either to your association rep or to legal as quickly as possible to at least have a conversation to see whether or not it makes sense to seek standing on that situation, or whether or not you want assistance with your preparation in other ways. And don't just assume that just because the service itself has standing, that fully protects your interests as an individual officer, depending on your involvement. Again, that's why having a conversation with legal is helpful. And just as an overarching point of guidance, regardless of your involvement, I would just say to take that review and your preparation very seriously, as the results of these inquests are public and often reported on. So it can have an influence on how you are seen, as well as how the service is seen as a whole.
Thanks, Darren and Jessica. Amazing presentation for both. And Jessica, you're totally right. Being part of quite a few of those inquests in the past, especially a lot of emotions run wild of those, especially with the family members. And the one good thing I'd say within the province is usually the legal of the service and the lawyers that we use, which is McDougall Gauley, will have those conversations with the association. If it's something that they feel the service, there isn't that jeopardy, the service might run it. But for the most part, we usually do get our own lawyers. But there'll be lots of conversation around that, and that decision will be made all together. One thing we'd really like to appreciate is if you will connect with us. You can locate us on X at SaskFedPO, Facebook, and LinkedIn. We will be posting a survey afterwards. Please let us know what we could do different. We're trying to do these for our members. Was the time of day good? We usually have it on a Wednesday. We understand we have shift workers. Was it need more information? Too long? Too short? Those sort of things. So post-webinar survey will go out along with the videos. And hopefully some more future webinars. Please also let us know if there's any other webinars you feel that we should be looking into, any other topics, whether it has to do with member wellness. We've looked at doing some on physical activity, physical fitness, mental health, and also other legal aspects and labor issues. I know someone brought up maybe even look into harassment investigations, as we've been seeing a lot of those lately. We also ask that you follow us because we do have the Blue Spirit Award, which is presented to members who do great work as within their service, but also out in the community. And we have awarded those awards, one in Saskatoon and one in Estevan. And if you go to our website under the Blue Spirit Award, you can nominate one of your fellow employees for that award. There's a lot of great stuff on our website. There's member discounts through different vehicles. We're just actually have a meeting with Sport Check coming up here this week to provide even more member discounts, things like that for members. So there's so much information. It is open to the public, but we do have a member access only. You have to register for it. It usually takes half a day to a day for that to get approved. So just really want to thank everyone on behalf of the Saskatchewan Federation of Police Officers. Thank you for taking your time out. We know everyone's very busy. Thanks for taking the time out to listen to this important subject, and just want to thank you all, and everyone stay safe.